And welcome. Today we are talking about the young thug and Trump prosecutor Fani Willis and the allegations of wrongdoing that has popped up against her. We will be going through the timeline, the proposed Georgia Senate investigation against her for misuse of funds, and then we go to the Nathan Wade divorce. That and whatever you can come up with in the chat that you feel I should talk about. And yeah, that's today's show. All right, yeah. Welcome everybody. Hello Gigi, hello Alicia, Chelsea, Rob Mill. I saw Anne and Honey earlier, and Christine was here quite early. And hello everybody over at Rumble. Yeah, since this has a bit of Trump in it, sometimes YouTube doesn't like it, so I am having a Rumble stream parallel to this. So if YouTube decides to, the Rumble stream is pinned on the top of the YouTube chat. Hi, Siren Pickle over at Rumble. So let's get right into it with the timeline. We need a bit of the basics here. And let's see here. Dun, dun, dun. Nope, not that one. Yeah. Timeline. January 1st, 2021. Willis assumes office as Fulton County District Attorney after defeating her former boss in the Democratic primary and running unopposed in the November election. February 10th, 2021. Willis sends a letter to top Georgia officials, informing them of her initiation of a criminal investigation into possible interference in the state's 2020 general election. In the letter, she instructs them to preserve evidence without explicitly naming the former president. The recipients of the letter includes Governor Brian Kemp, Lieutenant Governor Jeff Duncan, Attorney General Chris Carr, and Secretary of State Brad Raffensperger. Oh, I should have Dave here and try to pronounce these names. November 1st, 2021. Fani Willis hires Nathan Wade as a special prosecutor in the investigation, while she reportedly offered the job to several other Georgia attorneys, including former Governor Roy Barnes and former federal prosecutor Gabe Banks. They declined due to the time the case would require and the politically incendiary nature of the case. The day after this, Nathan Wade files for divorce against his wife Joycelyn Wade in Cobb County Superior Court. The day after, he sees an amazing payday. He files for divorce. This will become important. January 20th, 2022. Wade requests Fulton County Superior Court to impanel a special purpose grand jury to investigate possible attempts to disrupt the 2020 election. May 2nd, 2022. A special purpose grand jury is impaneled to investigate attempts by former President Trump and his supporter to overturn the Georgia loss. June 1st, 2022. The special purpose grand jury is seated. They hear from 75 witnesses, including former New York Mayor Rudy Giuliani, Georgia Secretary of State Brad Raffensperger, and Governor Brian Kemp. Here it comes interesting. October to November 2022. On October 4th, Wade spends more than $1,300 for 3 American airline tickets for himself, Willis, and Clara Bowman, who is another one. I believe she is another of the prosecutors. According to credit card statements. The statements also show more than $8,000 in charges from Royal Caribbean Cruises, Vacation Express, the Hyatt Regency in Aruba, and Norwegian Cruise Line. There are no names associated with those charges. Allegedly, that is where he took DA Fani Willis for thank you vacation for the money he so far had been paid by the Atlanta taxpayers. December 15th, 2022, the Special Purpose Grand Jury issues a sealed report. One of the four persons says recommends indictments against more than a dozen people. January 9th, 2023, Fulton County Superior Court Judge Robert McBurney, who oversaw the special grand jury, states that the panel has completed its work and submitted a final report to him. April 25th, 2023, Wade spends $117 on Delta Airline tickets to San Francisco. His and Willis' names appear on the credit card statements. It would be interesting to find out who paid for the hotel, the meals, and with whose credit card. I would assume, since it's not on Wade's, it might be on Willis. May 14th, 2023, Wade spends $840 for what appears to be a stay at a DoubleTree Hotel in Napa Valley. However, Willis' name does not appear on the credit card statements. Oh, we got a Broken Baker raid. Hello, Baker raids. Hey. Thank you so much. Much appreciated. I always enjoy a Baker raid. Let's continue with the timeline. July 11th, 2023, Fulton County grand jurors are sworn in to begin considering charges against former president and his alleged co-conspirators. August 14th, 2023, former president and 18 other people are indicted by a Fulton County grand jury accused of scheming to illegally overturn election. January 8th, 2024, Joycelyn Wade, through her attorney Andrea Hastings, attempts to serve Willis with a notice of deposition. The subpoena was presented to an employee at the office of the Fulton County District Attorney. January 8th, 2024, an attorney for defendant Michael Roman files a motion seeking to disqualify the DA's office from the case because of an alleged romantic relationship between Willis and Wade. The court filing states that because Wade paid for trips they took together, Willis benefited financially from the arrangement. Roman's lawyer, Ashley Merchant, asked for the Wade's divorce records to be unsealed and also wants the charges against her client dropped. The DA's office say they will reply in a court filing, but doesn't indicate when that will be. January 12th, U.S. House Committee on the Judiciary Chairman Jim Jordan announces an investigation into Fulton County Special Prosecutor Nathan Wade. January 14th, Willis defends Wade during a 35-minute speech at the historic Big Bethel AME Church. She calls him a superstar, a great friend, and a great lawyer, but does not confirm or deny a romantic relationship. She suggests racism is behind the accusation that he is not qualified to be a special prosecutor, noting that critics targeted Wade, who is black, and not the two other special prosecutors on the Trump case, who are white. She also, in this speech, claimed they were all paid the same hourly rate. We now know that was false. Wade is paid the most of the three. So, Fani Willis lied in church. Let's continue. January 18th, Willis seeks a protective order to stop her from having to give a deposition in the Wade's divorce. How about that? Willis accuses Jocelyn Wade of interfering with the prosecution and says her allegations are meant to harass and embarrass Willis. In my opinion, then she could just sit down in the deposition under oath and speak the truth. And if it's all meant to harass and embarrass, then what's the harm? January 19th, Jocelyn Wade's attorneys respond to Willis, attaching some of Nathan Wade's credit card records to their court filings. The statements show that he purchased plane tickets for Willis and himself, among other things. The former president's attorney, Stephen Sado, posted the court documents to his LinkedIn account. January 19th, Fulton County Commissioner Bob Ellis sends a letter to Willis demanding documents from her in an effort to determine whether county funds paid to Wade were converted to your personal gain in the form of subsidized travel or other gifts. Now, this is important because Miss Willis is not supposed to receive anything as the district attorney. Everything, if she needs to go somewhere, she needs to pay for it herself. If she needs to stay somewhere, she needs to pay for it herself. And then she has to get these receipts back to the office and have them approved just like everybody else. But apparently, she accepted these things from the special prosecutor she appointed, who's currently charged somewhere between $650,000 and $1 million for his work on the former president allegation case, whatever's. So that's very interesting. Dun, dun, dun. There. January 22nd. In a hearing, Cobb County Superior Court Judge Henry Thompson says the Wade divorce records were improperly sealed and agrees to unseal the records. He also issues a stay related to Willis' deposition, saying it doesn't make sense for her to be questioned before Wade. January 22nd. Chairman of Georgia's Senate Committee on Transportation and Chief Deputy Whip Senator Greg Dolezal introduces legislation to establish the Senate Special Committee on Investigation to look into allegations of misconduct involving Willis. January 25. Former President joins Michael Roman's motion to remove Fulton County District Attorney Fani Willis and Special Prosecutor Wade. Trump's chief complaint is Willis' speech at the church on January 14th. Yeah, where she lied in church. January 25th. Georgia Representative Marjorie... Oh, God. Okay. Files complaint with Georgia's Ethics Commission against Nathan Wade over his purported failure to register and file lobbyist paperwork disclosing his solicitation of Fulton County DA Willis and excessive gifts to the prosecutor. Okay, let's just remove her name from this because she's a nut job. But this is proper. This is proper. January 31st, evidentiary hearing in the divorce case scheduled in Cobb Superior Court. February 2nd, deadline given by Fulton County Judge Scott McAfee for Willis to respond to Roman's motion. February 15th, Fulton County Superior Court Judge Scott McAfee is scheduled to hold a hearing to consider Roman's motion. So that is the past and the future. And in my opinion, it seems, I mean, a district attorney, the appearance of misconduct should be enough. And in my opinion, it doesn't look good at all. I mean, Royal Caribbean and Norwegian cruises. Yes, John and Chelsea, I can't, I'm only 16 minutes in. I can't say all the words about Marjorie Green. But in this case, that filing is proper, in my opinion. Now, let's talk about the unsealed divorce. And this is from Fox 5 Atlanta. Bum, bum, bum. Unsealed original divorce documents don't mention Fulton County DA Fani Willis. So why did he have them sealed? Why? Is it the very weird date where he filed for divorce, the day after he was appointed special prosecutor, awaiting an enormous payday? Why file for divorce then? Well, may or may not be because he wants to keep all that money for himself and not share it with his soon-to-be ex-wife. Fulton County, the recently unsealed records pertaining to the divorce of Fulton County Special Prosecutor Nathan Wade do not provide any new evidence of an improper clandestine relationship with his superior, Fulton County District Attorney Fani Willis. Yep. And here, Nathan and Joycelyn Wade was married on June 21st, 1997, and separated on August 15th, 2021, with Nathan filing for divorce on November 2nd, 2021. In her counterclaim, submitted November 30th, 2021, a comprehensive list of interrogatories, something like that, was included. These questions covered financial matters related to Nathan Wade, along with personal aspects, including sexual partners and casual meetings with women other than his wife during their marriage and separation. Social media, dating website activities, and inquiries about alcohol and drug usage. Allegations. These are questions she wants answered in the divorce proceedings. Nathan Wade responded to Joycelyn's counterclaim and interrogatories in December 2021, but according to Joycelyn's attorney, the response was deemed woefully inadequate, as it included only a few incorporation documents, one bank statement, and minimal answers to personal interrogatories. Jesus Christ. Hello, Rabbit. Thank you for being a member for 5 months. Thank you for your unbiased coverage of this. Yeah, I think I'm very suited for covering things like this because I don't have a skin in the game in the Trump thingies. I think it's fascinating, but my main focus here is the misuse of funds that were supposed to take care of the backlog in the court for the courts. I mean, Mr. Roman's attorney claims indicted and unindicted over 200,000 cases, stemming back from as early as in the early days of 2020. These are people who have been waiting now for 4 years, and the statute of limitations are running out on a lot of the misdemeanor cases. people who will never find justice, who will never have their day in court. Because Fani Willis wants to be an attorney general. And Christine Fortunato, member for 6 months. Wow! Thank you for having me in the chat. Thank you for being in the chat. 200,000 is Atlanta Crime Center. Atlanta, Fulton County is a huge county. I believe it involves the entirety of Atlanta. Let's see here, and Atlanta, Georgia has close to 500,000 inhabitants. And the surroundings, that's Fulton County. So yeah. So it's a huge place. Oh, Erin Olivia, also member for 6 months. Crap, I got 6 months too. Where did the time go? Time flies when you're having fun. Oh, thank you so much. And for everybody else, if you also want to become a member, it's $3 a month. And you get access to all the members-only content and to my Discord. But thank you for being members for so many months. Thank you so much. Now, where were we? Yeah, here. Over the subsequent 2 years, Joycelyn Wade's attorney repeatedly complained about Nathan Wade's willful refusal to provide the requested documents or answer interrogatories. In May of 2023, the court ordered Nathan Wade to submit all outstanding documents, including tax records and pay stubs, which he partially complied with in June 2023. Subsequently, he faced contempt charges in August of 2023 and was directed to provide additional credit card statements and law firm records. Oh, John Communion, member for a month, says, thank you, and Mr. Jingles for a month of awesomeness. Thank you for being here. It's thanks to people in the chat, my viewers, my subscribers, and you make it worth it. So with this, he faced contempt charges. I know that divorces can be rough on people and that you don't really want to submit things, but Georgia is not a no-fault state. Depending on what Joycelyn Wade finds out, it has to go. Because remember, Nathan divorced her. I don't know, they have 2 children together. And he's out there spending thousands and thousands of dollars on District Attorney Willis. Money that may or may not should have been shared with his soon-to-be ex-wife. Let's see here. In September of 2023, Joycelyn Wade filed a motion to reopen discovery, alleging that Nathan Wade, while appointed as special prosecutor in this case, was leading a lavish lifestyle, spending substantial amounts of money, leaving her with minimal financial support. In December of 2023, Nathan Wade reportedly produced some outstanding discovery responses, revealing credit card statements indicating non-work-related trips with District Attorney Fani Willis. As a result, Joycelyn Wade served Willis with a notice of deposition on January 8th. Wade has not admitted to a romantic relationship with Willis. And defended him. Willis has not admitted to a romantic relationship with Wade and defended him in a speech at the historic Bethel AME Church on January 14th. She sought a protective order against the deposition, which the judge granted at least temporarily. That was January 14th. We have an update on that, by the way. Are the children adults? Dun, dun, dun. Bum, bum, bum. I don't find their birth date. So far, I'm calling them kids, just to be on the safe side. Just to be on the safe side. Mads says, Joycelyn would say that though. I mean, I never heard of her before, but is this not normal in US divorce proceeding that takes a turn for the worse? I would assume so. That once Joycelyn may or may not have found out, oh, look at all this money he's spending that should go to the kids. I don't know what they have. I haven't read the divorce filings. I don't know if it involves alimony and child support, but if the kids are adults, then it's just alimony. But they are currently, I mean, it seems like the divorce haven't yet been finalized. It's just filed for divorce. And we know through another case I'm covering, the Ellison case, that divorce can sometimes take years. Sometimes. Let's continue here. The impact of the alleged relationship between Willis and Wade on the case against the former president and the remaining co-defendants, where 4 have accepted plea deals, remains uncertain. Calls for investigation into the matter have been made, including Fulton County Commissioner Bob Ellis, who sent a letter to Willis last week, and Senator Greg Dolezal, who introduced legislation to establish the Senate Special Committee on investigation to look into the allegations of misconduct. An evidentiary hearing in the divorce case is scheduled for January 31st in Cobb County Superior Court, and Fulton County Judge Scott McAfee has had a hearing to consider Roman's motion to dismiss his case on February 15th. So those haven't happened yet. Now, we come to the Willis hearing, where District Attorney Fani Willis, she doesn't want to be deposed. She absolutely don't want to be deposed. Maybe because she's not in a church where apparently she believes she could lie. She will be deposed, may or may not. But we will now listen to this one. The hearing on whether DA Fani Willis will sit for deposition in prosecutor's divorce case. And it is from 11 Alive. Closed captions is on. Let me know if the sound is okay.
All rise. Superior Court is now in session. Honorable Judge Henry R. Thompson is presiding.
Thank you. Be seated.
All right. Ms. Hastings?
Yes, sir.
Mr. Clyde, Your Honor, I am actually here on the second set of motions, the motions for access to the file, to unseal the file.
Where's Mr. Kimbrough?
Very good.
Oh, why don't you take that table?
Will do.
Your Honor, with your permission, I'm going to just sit up here.
That's fine. And Ms. Merchant?
Good morning, Judge.
Good morning.
I'm here for
And
the second.
I'm sorry?
I'm here as well for the second motion. So
Right.
I'm sitting back.
Why don't you come on up to the table as well? There's a chair for you.
Thank you.
And Mr. Axum.
Yes, good morning, Judge.
All right. Okay. Who wants to share in the takedown of this? Mr. Kimbrough?
Yes, Judge, will share.
Ms. Hastings? Ms. Merchant?
We'll share. Yes.
Okay.
We will as well, Your Honor.
Okay.
Thank you.
How about you, Mr. Axum? You want to share in the takedown?
Absolutely.
All right. Okay. This is Wade versus Wade. Civil action number 21-108166. And Mr. Wade is represented by Mr. Scott Kimbrough. Mrs. Wade is represented by Andrea Hastings. And we're here today for basically an emergency motion filed by Mr. Axum by a non-party deponent for a protective order. But there was already a pending motion to unseal the record filed by Ms. Merchant. I thought we might as well take that up at the same time. Now, this is my criminal jury trial week. I'm trying to start jury selection on the criminal trial, so we don't have a lot of time. All right, Ms. Merchant, I'll hear from you on your motion to unseal.
Okay, great. Thank you so much, Judge. Would you like me to podium?
Wherever you like.
Okay, thank you. I will be brief, Judge. Thank you. Judge, Rule 24 says that there's a very specific process that has to be followed for order sealing a record. It wasn't followed in this case. It was assigned to a previous judge, Judge Angela Brown, who entered a consent order under Rule 21, granting the seal in this case. It's our understanding from emails from counsel that Mrs. Wade's lawyers do not object to that seal order being lifted. I believe Mr. Wade's lawyers do, but we believe that it should be reversed and should be lifted because it was held without a hearing. It was held, as far as I understand, without a motion, and I can't guarantee that because I don't have access to those earlier records in the case because they are sealed. But it appears it was held, it was filed without an actual court hearing where the public was allowed to be present, and so that's in violation of Rule 21. There's very specific and stringent processes that the court must follow before a record is withheld from the public, and they were not followed in this case, Judge. The first is the motion, the second is a hearing, the third is that whoever wants it sealed has to identify specific parts of the court's file that need to be sealed. Also has to delineate the nature and the duration of the seal. None of that was done in this case. And the fourth, which is the most important.
Yeah, it seems like it was almost done as a favor that this prosecutor who just was appointed special prosecutor said to the court, can we have this sealed? But we don't know because the records are sealed. So we don't know. Now they have been unsealed, but I haven't read them yet. But it seems to me like it was done as a favor to one of the parties.
Part of it is the analysis that the court has to do. And what the law says in the seminal cases of Atlanta Journal versus Long, which we cited in our motion, that an order limiting access shall not be granted except upon a finding of harm otherwise resulting to the privacy of the person in interest, and that harm clearly outweighs the public interest. In this case, Judge, there's been no allegations of harm that clearly outweigh the public interest. And so the first thing to consider is whether or not that order needs to be reversed. And it's our position that it does because it doesn't follow the law. Second, getting to whether or not an order should actually be entered now, sealing this, we do not believe that an order should be sealed.
Has anyone filed one?
No one has filed one. So if you reverse the order at that point, if someone files it, then we can litigate that. But just focusing on the reversal of the prior order, Judge, I think the law is clear that it should be reversed, because none of those findings were made and the public didn't have an opportunity to be heard in that instance. So that's in violation of the law. And there's a couple different cases, I won't belabor the point, but all of the cases on this issue hold, if there wasn't a hearing, it's gotta be reversed. And so we think that order should be vacated. I've prepared a proposed order unsealing that, if the court is so inclined. And then if there is some type of a motion filed or an order motion, or an oral motion today to try and seal those records, if you are inclined to reverse, I'd like a chance to at least be heard on that as well. Thank you.
All right, thank you. Ms. Hastings, what's your position?
Your position, Your Honor. My position is that we did consent to the sealing at the beginning of the case. There was a motion filed by the plaintiff on November 18th, 2021, approximately 16 days after we filed this. We consented at the time. We have different information now. We also understand that there was no hearing conducted, so we have no objection.
Mr. Kimbrough.
Thank you, Judge. These parties did consent to this.
The stream seems to be a bit jumpy here, and that is not from my side. That is from the actual hearing.
Previous consent order sealed the record back in February of 2022. Because the divorce was filed November 2nd of 2021, answer was filed on November 30th of 2021, and this consent order sealing the record was filed on February 10th of 2022. Because it's clear that the parties' intent was at that time, and that was to protect their privacy. As such, a consent order was drafted between the attorneys who were involved at that time, of Ms. Hastings and her team were involved at that time. I was not. Did not get involved in this case until toward the end of last year. But that consent order was drafted and presented to the court, and it was signed and filed. And the judge, this court has a burden to determine what is in the best interest of these parties and what's in the best interest of this case. The law is pretty clear as far as this issue is concerned. Under the Atlanta Journal versus Long, 258 Georgia 410, it sets forth the purpose of Rule 21, which is the reason why we're here, dealing with access or limited access to court files. The purpose is, one, to protect the public right to access, which is a long-standing and traditional right, but also, Judge, that case holds that it is also to protect another traditional right, and that is the right of superior courts in exceptional cases to shield these records from public view. And the court has to weigh that. As far as this situation is concerned, the current status of this situation, that has happened since January 8th of this year, clearly shows the harm that is done to these parties, and clearly gives credence to what the parties' intentions were back in February of 2022 when they entered into this agreement to seal. And we think that that it is proper for the case to remain under seal. Now, again, I was not involved back in 2022 in this matter. It is my understanding there was not a hearing that was done. It was just a consent order that was prepared and presented to the court, not this court, but prepared and presented to the court, and that order was signed off on and filed. And so we think that if this court does, based upon those facts, unseal this record, that this court should also consider putting in protections for the parties' private information pursuant to 911.7.1, which allows this court to do that. Thank you, Judge.
Yeah, okay. Now I understand it better. Both parties consented. They presented it to the court, and the court deemed no hearing was necessary. So nothing shady going on. And we know now that the documents were unsealed, which revealed that there are allegations from soon-to-be former Mrs. Wade that her soon-to-be ex-husband was having improper relations outside of marriage. No names were in those filings, especially not Miss Fani Willis. But apparently some things have happened since then that makes Mrs. Wade believe that this relationship between Fani Willis and Nathan Wade was ongoing before he filed for divorce.
Your Honor, our motion is very similar.
I understand. Thank you. All right. I find that the prior order, although it was by consent of parties, was not properly entered because the Uniform Superior Court rules require a hearing to be had. We can find no evidence that any such hearing was ever had, so I'm going to grant the motion vacating the consent order, sealing the record. And I'll do that today. I'll have your written order, Ms. Merchant. Unless you have something else, you're excused.
I do not. Thank you so much, sir.
No wheel of regrets today. I have work tomorrow.
Yes. Well done, Counsel. Now we have Mr. Axsom's motion by a non-party deponent for a protective order.
Yes, now we come to the part in this hearing where Miss Fani Willis' lawyer argues that Miss Willis shouldn't be sat for a deposition. This will be interesting. I've heard about it, but I haven't actually watched it.
Mr. Axsom and Ms. Hastings has filed a response to that. Before we get started, Mr. Axsom and Ms. Hastings, I'll go ahead and tell you both. I've read the pleadings, so you don't have to read them back to me, okay, in making your arguments. Mr. Axsom, if you would, sir, I just need for you to focus your argument today on subsection 1 of your motion for protective order, if you don't mind. So you may proceed, Mr. Axsom.
Okay, thank you, Judge. Give me 1 second. All right. I know that you were asking me, and I will be brief, to focus on subsection 1. I think there is some low-hanging fruit that I don't know if it's come up. I don't know if the court had the opportunity to examine it. But before we get to subsection 1, I really do apologize. I would like to handle the issue as to whether the 2 subpoenas that have been served are defective.
Well, we don't need to reach that yet, Mr. Axsom. If you'll focus your argument on subsection 1 and tell me why the order should be granted. If it is granted, then we don't really need to reach the subpoena argument. So like I said, press for time. This is my criminal jury trial week. Just argue subsection 1.
I sure will. All right, so dealing with subsection 1, which deals with 26.1. Specifically, my argument hinges on the pleadings. And I have not seen the pleadings, but based on the argument that I put forward, this is an uncontested, it's a no-fault divorce, and based on that, both parties have alleged that it's irretrievably broken. And because they allege that, and the pleadings as they stand deal specifically with whether the arguments, hang on one second, give me 1 second.
Okay, what he is arguing is that at the time of the divorce, it was an uncontested divorce case. But we also know that since then, since special counselor, special prosecutor Wade has avoided discovery, has avoided to produce documents, and was at a point, as we went through earlier, he was subject to a possible contempt of court hearing. And not until then he started to produce more material. Among those were the receipts that showed Wade taking vacations with Miss Willis. The judge just said that he was in a hurry. You don't put him on hold.
The response in the plaintiff's pleadings alleges that it is permissible to bring up issues regarding the conduct of the parties. But I believe the pleadings are the things that set the boundaries. So in this case, a no-fault discovery alleging adultery is not relevant. The defendant brings up in the response that the plaintiff did not tell the defendant he was separated. The plaintiff did not comply with discovery until the motion was actually filed. The plaintiff may have used marital funds for the trip, but every one of those issues involves the plaintiff's actions during the divorce. Had nothing to do with Ms. Willis. The issue before the court, if it's a no-fault divorce, and it's irretrievably broken, is how do you define the marital assets? And that is the issue that was brought up in the response. So specifically, we're dealing with equitable division of marital estate, the dissipation of the marital assets, and the plaintiff's capacity to provide spousal support. So those three things are the things that the court has to deal with. All of those things sit squarely with the plaintiff. Ms. Willis does not share any accounts with him. D.A. Willis does not determine what he spends his money on, no matter where it comes from. So the issue is, if there's a no fault, and it's irretrievably broken, and the pleadings dictate the boundaries of the case, it's not relevant as to fault. It's not relevant as to the conduct of the parties. So that's essentially my argument with regard to the irretrievably broken in 26.1. I believe 26.1 protects, because this District Attorney Fani Willis is an officer as it is defined in 26.1. So it protects her.
I assume that 20 divorce law, yeah, 26.1. Okay, 26.1 is, let's see here. let's see here. This is the issues while not being in the US, and I believe the 26.1 is since Miss Willis is a high-ranking public officer, she has some sort of immunity. But I'm not sure that is. I think that is only for criminal and lawsuits against her, not to be deposed as a witness of sorts in a divorce case. So that is my. I haven't seen this yet, but she seems to be relying on immunity. Let's see where they go with that.
And according to 26.1B, there are two requirements that have to do that. The officer has to be high ranking, and I don't think that's in dispute. When we look at Ms. Willis and the demands on her office, Ms. Willis has Fulton County Office of District Attorneys. The only way I can put this in context is to give you some background on that. She manages a staff of 360 plus lawyers and staff. She oversees cases right now, 20,000 open cases. She coordinates on a monthly basis at least 500 or more cases for.
Oh, that's a really interesting argument, because we know that money that was given from both allocated money within Fulton County and possibly federal funds was given to Fulton County, the Fulton County courts and her office, to remove as many cases from the court docket as possible. And she chooses, among other things, to hold 2024 3 simultaneous RICO-trials. It was 4, but one has pled out, the YF and rapper. He pled out.
So, in this case, of course, the most recognizable issue is that she's dealing with, for the Fulton County election interference case involving former President Trump.
Well, I'll tell you what, Mr. Axon, let me interrupt you. Let me
Yes.
ask you just to focus on a part of the law that says the proposed opponent lacks unique personal knowledge of any matter that's relevant. Are you saying that your client lacks unique personal knowledge that could not be discovered some other way?
I would argue that she does, that the knowledge that she may or may not have is not unique. You've got two parties in the case, one who is alleged to have some extramarital affair with Ms. Willis. If that is the case, if that is true, he has that information.
So her lawyer doing the, if it's true, if it's not true, whatever it is, then Nathan Wade should have that information, and that makes her deposition unnecessary. I personally, I don't buy it. I really don't, but that's me. You can disagree with me or agree with me, but I don't buy it. For me, if it is marital issues and more or less the money he is bringing in that he's not sharing with his still wife, the person who he's spending that money on should be deposed, because Nathan Wade has, through these proceedings, which we now have found out more about, has done everything to hide his assets from his soon-to-be ex-wife. So I wouldn't trust information from him directly. I need it corroborated by another source, in this case, Miss Willis. And then personally, I would love to hear about what kind of work they discussed on a cruise ship.
We've been at this case, or I have, but 783 days. And on day 776, somewhere in there, we get this notice of deposition. So to focus on that part of the section, no. I think there are other means by which that information can be retrieved in this case.
All right, thank you, Mr. Jackson. Ms. Hastings?
Oh, please make it spicy. Please make it spicy. It's already spicy, but I want more spice.
Where?
Your Honor, I think that you honed in on exactly what the issue is here today, naturally. The face of her pleading shows that she has unique knowledge with regards to this case. She could have filed a motion for protective order alleging all of the legal grounds for which she would like to not have to sit for a deposition, and she believes she's protected. But she didn't stop there. She went further. She asserted in her pleading, her motion for protective order to prevent herself from sitting for a deposition, that she knows the cause of the separation of these people. She knows detailed facts, allegedly, about their relationship. And albeit we'll deal with the falsity of those at a different hearing, that's what she said. She said it in her pleading. So on its face, her argument fails that she does not have unique knowledge with regards to the party's marriage and this situation. Beyond that, Your Honor, I would turn the court, obviously, to 911-26C and Ewing versus Ewing, which clearly states a party seeking a protective order with regards to discovery, when a party does, the trial court may make an order which justice requires to protect the party or person from annoyance, harassment, oppression, etc. However, protective orders should not be awarded when the effect is to frustrate and prevent legitimate discovery. Furthermore, the Georgia Court of Appeals has held that protective orders are intended to be protective, not prohibitive. And that's exactly what DA Willis is seeking to do in this case. She's not seeking protection, she's seeking prohibition of our ability to access facts. I can state as an officer of the court in my place here today that the first time in the 783 days that this case has been pending, the first time that I heard that the alleged cause of the separation was some false claim with regards to my client in 2017 was in her pleading. So I have questions. And that's just the beginning of it.
It got spicy. It got spicy. Ooh. It seems like, as the Scorpion lawyer here says, the plea in itself, the pleading in itself from Fani Willis indicates she has unique knowledge. That's interesting. That's interesting. Yeah, I don't remember this lawyer's name, but I will call her the Scorpion lawyer because she has sting. Haha! She saw an opening and shkbunk. Shkbunk? What the? Yeah. Whatever a scorpion sting sounds.
Furthermore, Your Honor, the black letter law in the state is that in divorce cases, in which equitable division of property is at issue, the conduct of the parties, including evidence of the spouse's alleged adultery, is relevant and admissible. We don't have to plead adultery in the initial petition. But we also have the ability under OCGA 91115 to amend the pleadings anytime up until the entry of a pretrial order. We have the right, regardless of whether or not the grounds for divorce alleged in the petition is that the marriage is irretrievably broken, to discover information with regards to adultery. We have questions. I want to know about how he's been spending his money. I have a reason to believe he's spending it on another woman. That's my client's money. And I want to ask questions about that. She's trying to hide under the shield of her position improperly, I would suggest, Your Honor. There's a couple things that are improper about it. First of all, and I'd like for the court to clarify this.
If you're ever getting a divorce in Georgia, Scorpion lawyer. Ooh.
There's no doubt that she's busy. She has one of the most active district attorney offices in the state. However, as Mr. Axum cited under 911-26.1 D2, if you look at that, it says the person seeking the protective order had unique personal knowledge of one or more matters relevant to the subject matter. We know she did. She put it in her pleading. We also know that she did because although she asserted falsehoods in her pleading, we asserted facts in our response. And those facts, even the ones we've just shown, clearly demonstrate that she's got some unique personal knowledge in this case. But more than that, we're not seeking her deposition as the district attorney of Fulton County. We're seeking her deposition in her individual capacity as the alleged paramour of my client's husband. So whatever her job is has nothing to do with whether or not she should have to sit for this deposition.
I agree. District Attorney Fani Willis is trying to hide behind her position in order to protect herself from sitting in this deposition. No. Dun, dun, dun. This will be interesting to follow.
I'm sure that it's inconvenient. It's inconvenient for all of us. However, I have questions, and she needs to answer them. I want to bring one other matter to the court's attention with regards to her position that I think has not been highlighted in this. With regards to her position, in her motion, page 9, top of the page, she stated unequivocally, D.A. Willis stated that if we pursue this subpoena, we are obstructing justice.
Yeah, Ms. Hastings, that's why I told Mr. Axum to stay away from that. Because I don't think I want to hear that today.
Yeah. Fani Willis, in her motion, between the lines said, if you pursue this subpoena, I might charge you with obstruction of justice because you're getting hinders in the way for the Trump prosecution. She more or less threatened Mrs. Wade and Scorpion lawyer to file charges against them. In my opinion, that speaks to the absolute desperation from District Attorney Fani Willis. That in itself is improper conduct from a district attorney, in my opinion. I found the defendant's response to Fani Willis' objection to sit for deposition. I will read from that. It's just, I think it's 4 pages long. No, it's 19 pages long. Well, I will read some of it, the spicy things, after we are done with this hearing.
Got it. Okay. Then, Your Honor, that is our argument with regards to the propriety. It's clear that she has relevant information.
Okay, Ms. Hastings, correct me if I'm wrong, But in the over 2 years this case has been pending, we have yet to hold an evidentiary hearing where we heard testimony of either party. Is that correct?
That is correct, Your
We've
Honor.
been up to now dealing with discovery disputes.
Yes, Your Honor.
Okay.
Well, not quite. There's been a discovery dispute, which is entirely one-sided with Nathan Wade's simply don't want to share information.
And neither party has been deposed.
Correct.
All right. Okay. Thank you.
Thank you.
Mr. Kimbrough, you have anything to add?
I do not.
You're sitting this one out?
I don't know.
Okay.
We'll take it before I read on that.
All right. Well, both sides have good points. Ms. Hastings, I agree with. The irretrievably broken does not prohibit you from presenting evidence of adultery if that's relevant to equitable division of marital estate or marital assets. So I agree with you there. You're not prohibited from getting into that. However, I also agree with Mr. Axon that OCGA 91126.1 is there for a reason. And the key part to me is whether the proposed opponent lacks unique personal knowledge or has unique personal knowledge of a matter that's relevant to the subject matter. And under D1 of that statute, that the party seeking the deposition has exhausted other reasonable means of discovery and found such discovery to be inadequate. So really, I'm not in a position where I have sufficient information to make a finding either way of whether the proposed opponent has unique knowledge. Because this case is a divorce, and I understand there are children, but they have attained the age of majority. So we don't have to deal with child custody or visitation or child support or who's going to have the final say on medical or educational or religious issues. So that takes out a large portion of what people normally fight over in divorces. It seems to me, you can correct me if I'm wrong, that what we have here is a math problem. Equitable division of the marital assets after determining what they actually are, alimony, and attorney's fees. That's a mathematical equation that we need to solve. The solution will be a number or three numbers, but the numbers will be expressed in dollars and cents. And without Mr. Wade having been deposed yet or given sworn testimony yet, I'll note for the record we have a hearing set for 9 days away where sworn testimony can be presented. Without me knowing what Mr. Wade would say, it seems to me that Mr. Wade would be the first and best source of information on what his income has been and how he's been spending it, and that he would have firsthand knowledge of whether he's engaged in an extramarital affair. Only after I hear what Mr. Wade has to say do I think I can make a determination of whether the proposed opponent has any unique knowledge about these issues. Because once again, this is a math problem and that we need to find a solution to. So, with all that being said, I'm not prepared, Mr. Axon, to grant your protective order, but since the deposition is set for tomorrow and our first evidentiary hearing is set for the 31st, I will issue a stay. And I will stay the deposition until I'm in a better position to make a determination of whether the proposed opponent would have any unique knowledge, unique being the key word there, that is not possessed by Mr. Wade himself. Now, if there's not anything else, I need to seat a jury in a criminal case.
All right. Well, that's the end of this hearing. And the protective is gone. But deposition is on a stay, which means it's on a hold. The judge wants to hear from Mr. Wade. It's a non-ruling. Yeah, it seems fair, because it all comes down to what Mr. Wade said in his deposition. That was scheduled 2 days after that hearing, which and that deposition should already have been taken place. The evidentiary hearing based on that is on the 31st, which is on Tuesday. And depending on the Young Thug trial, if the judge in the Young Thug trial decides to take another vacation or have another emergency or whatever happens, I will probably try to cover that if it's streamed, or I will wait for the documents. But first, I promised you this. The defendant's response to emergency motion by non-party deponent for protective order comes now. Good for her. The defendant, Jocelyn Wade, by and through her counsel of record, and hereby files her response to non-party Fani Willis's emergency motion by non-party deponent for protective order, and would demonstrate to this honorable court as follows. Introduction. Dun, dun, dun. Non-party Fani Willis seeks this court intervention via protective order to avoid sitting for a court-ordered deposition. The argument asserted by Ms. Willis are disingenuous, spacious, and her claim basis for same fails as a matter of law. Upon information and belief, Ms. Willis has information and knowledge directly relevant to alleged conduct of the plaintiff that would be considered by the court as to equitable division of the marital estate, dissipation of marital assets, and spousal support. Yeah, Georgia is not a no-fault state, which means the more shady business Mr. Wade was into, the more money Mrs. Wade can get from him. That is roughly what that means. Furthermore, Ms. Willis' implied threat to pursue charges against defendant and her counsel based on inconvenient facts from her personal life that are directly relevant to the ongoing divorce proceedings in the above state action is an affront to the integrity of her office. Contrary to the assertions in her motion, Ms. Willis' prevarications regarding defendant's conduct in her marriage seems to demonstrate that Ms. Willis does, in fact, possess intimate information about the Wade's marriage, albeit false and libelous misinformation. Background. Plaintiff was appointed as a special prosecutor by Ms. Willis on November 1st, 2021. Plaintiff filed for divorce on November 2nd, 2021. Defendant was served by process server on November 3rd, 2021. Before defendant even filed her answer and counterclaim, plaintiff filed a motion asking the court to seal the record in this divorce action. Well, now we heard that it became uncontested, but it was wrong, and now we have all the filings. Or at least they are public for people who want to find it. Well, yes, Gigi. This is no longer a non-contested divorce. It was in the beginning, but it seems like the more Mrs. Wade found out about her soon-to-be ex-husband, the more she realizes what an absolute dog he was. Bum, bum, bum. Plaintiff filed a motion asking the court plaintiff did not reveal to defendants his appointment by Ms. Willis or the substantial income he has been receiving throughout this divorce case as a result of that appointment. And defendant did not discover the same until much later in the proceedings. Plaintiff also left defendant with little means of financial support while simultaneously spending tens of thousands of dollars per month on a very lavish lifestyle. Plaintiff willfully failed to comply with his discovery obligations in the very divorce case that he initiated, which led to the court holding him contempt of this court's order on defendant's motion to compel discovery. So he was in contempt. I'm not sure. I haven't seen that. In the timeline, it said he only risked contempt. Well, on December 22nd, 2023, plaintiff only produced a portion of his outstanding required discovery responses. In these responses were credit card statements which demonstrated that plaintiff had paid for and taken trips unrelated to his work with the Fulton County District Attorney's Office. Yeah, that's the cruises on the Royal Caribbean and the Norwegian cruises, allegedly with District Attorney Fani Willis. It's still allegations. Since plaintiff filed for divorce, he's taken trips to San Francisco and Napa Valley, to Florida, and even gone on Caribbean cruises, enjoyed a trip to Belize, another through the country of Panama, and even just last month took a trip to Australia. The evidence is clear that Ms. Willis was an intended travel partner for at least some of these trips, as indicated by flights he purchased for her to accompany him. True and accurate copies of credit card statements showing purchase of plane tickets for plaintiff and Ms. Willis are attached. Yeah, and then it's an argument to depose Ms. Willis. But we now heard that the judge ordered a stay on that because he wants to hear what Nathan Wade has to say first. And then I assume in the hearing they will argue Nathan Wade is a dog and possibly a non-truth teller, so we need to depose Miss Fani Willis as well. Becca Lynn says, well, you can't go on Caribbean cruises without going to Florida first, and it's not like Georgia is across the country. Yeah, so the plane tickets to Florida, paid with credit cards with both his and Miss Willis' name, is... Yeah, this is interesting. But that is as far as I know stuff about the allegations against Fani Willis. I know that there will be an investigation if the federal funds was misused. So that is also ongoing. I will keep a tab on it, but my main focus is the Young Thug trial. And it should restart tomorrow. And I will have a recap at around 5:30 p.m. tomorrow on what was going on. Because one, judge is either late or not there. Somebody might get stabbed again. I don't know. It's hard to know with the Young Thug trial how that trial will go. So we'll just have to wait and see. And that is why I only said I will have a recap on the Young Thug tomorrow. Because it might be that the judge decided his emergency is for another week. We don't know. And it's, in my opinion, is so disrespectful to the court, to the defendants, and to the jury, whose time he's wasting. But that is about it of what I have for you today. I will see if I can... Okay. RC Overlord is doing something, so I will get you over to his stream. Thank you all for showing up. Thank you all for that. I hope you did all the thumbs up. I hope you already are subscribers, or if I earned your subscription today. Same over at Rumble. If you choose to follow me on that platform. I'm also streaming this on Twitter. So give me the heart thingy there if you have the time. But I will see you all back here tomorrow for the Young Thug trial. And if that is unclear, if it's even a trial day tomorrow, I will find something else to talk about. Either way, I will see you all back here tomorrow. Thank you so much. Have a great day. Hug your family. Unless your family is crap, then hug the people that deserves your love. Bye-bye.